Good morning to all of you. Andariki Shubhodayam. Welcome to Legal Matters by Sai Babu Sunkar. మొదటిగా అందరికీ దీపావళి శుభాకాంక్షలు. CPC class. You can take it as a class of res judicata. You can take it as a class of forum shopping. Honorable Supreme Court of India, Justice Madam B.V. Nagaratna and Satish Chandra Sharma, in the case of Thiru Nagalingam versus Lingeswaran, SLP 17,575 by 2023, on 13th May 2025, held that once the Supreme Court gives an order, that order attains finality, and filing another appeal almost with the same grounds in a high court, it is nothing but abuse of process of law, it is nothing but res judicata, because when once a case is finalized, that's all. You should not deviate by filing in another case. Sorry. Right. So, Honorable Supreme Court of India held that if an application filed under one provision has been finalized, has been dismissed by the Supreme Court or by the competent court, another application filed under the guise of another provision but with the same contentions is nothing but abuse of process of law, dismissed. Right? Now, let us understand the case facts. Already, I think yesterday or the day, yesterday only, I told you maybe 4,200 the video. I told you the case of Kankanale, Surya Prakash Rao versus Kampa Bhaskar Rao. Same type of case. Even, right, it relates to OS number 110 by 2015 on the sale agreement dated 17/8/2015. Actually, Thiru nagalingam, he purchased property and agreement to sell was agreed, that is drafted on 17/8/2015, and this man has given to 3 lakhs as advance. Having taken advance from Lingeswaran, Thiru nagalingam failed to perform his part of obligation. Ante register cheyala. Then he has to go and file an OS before the Honorable Court, JCJ Court at Ramanathapuram. Then this agreement, Thiru nagalingam, right. During the pendency, when he filed, then they filed the others, that is Thiru nagalingam. When he filed the so-called OS, 2 persons filed their return statements. One is Lingeswaran and second one is, as Lingeswaran has already drafted another agreement to sell to another person, that is R2. Right? He stated that this man, Lingeswaran, has given an agreement to sell without registration. Sale deed dated 26/11/2015. That means he has done double registration and he has given 2 agreements. ఏముంది సంతకాలు దేనికైనా పెడతాం మనం, తెలిసిందే కదా. Right? And incidentally, even though they filed the return statement, they did not attend the court. So, even though they were asked to attend on certain date, both of them evaded from attending the court. As such, the court has no other go except to hear and give the decree ex parte. Ex parte decree was given on 7/2/2017. పర్లేదు, 2015లో వేస్తే 2017లో డెసిషన్ వచ్చేసింది. When once the decree was given, normally this man is intended to file EP number 10 by 2017. Now, these people, Lingeswaran and another, they filed an application. They preferred two applications literally. Under Order 9, Rule 13. What is Order 9, Rule 13? Setting aside the ex parte decree. Right, of course, there is a delay. For one, the delay is 712 days. For the second person, 467 days. No doubt, the trial court allowed and set aside the same. But this man, this is Thiru nagalingam, he has filed a revision before the High Court. High Court on 9/11/2027 said, no, setting aside is not correct. Setting aside not correct. So therefore, Thiru nagalingam filed once again an SLP before the Supreme Court, 2054/2025, and Supreme Court dismissed it in limine at the threshold, stating that such a delay can't be accepted, so the High Court is correct. That means when one Supreme Court dismissed, the order attained finality. But once again, they initiated the second litigation before the High Court, that is a regular appeal against the ex parte decree. There are two methods. Whenever a plaintiff is rejected, whenever ex parte decree is given, normally you try to set aside. Now this man has gone for an appeal against the ex parte decree. Once again, the other people said it's barred by limitation. So, because yes, and the limitation, High Court somehow on 25/4/2023, they have shown a consideration and asked these people to pay 1 lakh to the to the appellant, that is Thiru nagalingam, and proceed with the case. So once again, no, not satisfied, he has come to the Supreme Court. So any twist and turns anyhow. Now Supreme Court said, and once we are given an order in the same matter, after discussing all these things, it's final. How can they take another shape? There you filed the set-aside petition, we have not allowed it. Now you want to go for appeal on the same thing. What is the use? That's why res judicata, constructive res judicata. When once you want to institute a case, when you want to offend or defend, your contention should be all put together, not piecemeal, just like we stated in the case of State of UP versus Nawab Hussain. Okay, so please remember, when once the Supreme Court orders are given, it attains finality, and you can't twist the matter by filing another case in another shape. This is otherwise called as forum shopping. అక్కడ హైకోర్టులో తెలిసినట్టు ఉంటారు, చేసి ఉంటాడు. అర్థమైంది కదా? ఓకే, అంతకన్నా కామెంట్ చేయటం బాగా. థ్యాంక్ యూ.